Good morning, friends. I would like to share my views on the ongoing controversy in respect of Citizenship Amendment Act 2019 and the notification of its rules and its implementation, whether it is an affront on the constitutional core objectives and how it affects the principles envisaged under the preamble of the Indian Constitution. Friends, if you carefully observe for the last 9 years, whatever the Modi government do or implement, its timing is always in pursuit of its majoritarian agenda and electoral benefits by polarization of the society and communal lines and divide, and its political message always is to the effect that all its policies will have underpinning a religion. The latest example being its decision to implement the Citizenship Amendment Act 2019 by notification of CAA rules on 11/3/2024, just a few days before the announcement of general election schedule by the Election Commission of India, which was announced on 16/3/2024. As all of us know well, that when the Citizenship Amendment Act was come into force in the year 2020, there was stiff opposition and a series of protests all over the country from larger sections of the society and concerned citizens opposing CAA 2019 as it is discriminatory in nature on the basis of religion, resulting in arrest and incarceration of many citizens, civil rights activists, especially from Muslim minority community. There were more than 200 petitions filed before the Honorable Supreme Court of India challenging the validity of CAA 2019 on the ground that it violates the Article 14 of Indian Constitution. And of course, they said petitions are yet to be taken up for a hearing. Further, it is very pertinent to note that the Modi government, for the reasons best known to it, did not choose to notify the rules and implement CAA 2019 for the last 5 years, and its sudden decision to implement on the eve of elections naturally raises suspicion about its intentions, and there is widespread impression among the general public that it is an attempt to divert public attention from the ongoing electoral bonds scam controversy and the revelations of payments or donations made to the political parties, and the largest beneficiaries being the BJP. So with the disclosure of these details of purchasers of electoral bonds and the list of beneficiaries of their donations, which exposed that many of the purchasers of these electoral bonds and donors are the victims of Enforcement Directorate or income tax rates. Further, on critical examination of the CAA rules notified by the government, it is clear that there is no scope of state government's intervention or impeding its implementation, which is in violation of the federal spirit of the Constitution of India. And in fact, this disclosure of electoral bonds has put the Modi government in a tight spot and also caused a high degree of embarrassment to it. So the underlying message of the timing of the implementation is very clear, that it is to divert public attention from this electoral bonds scam, and also it is for the purpose of polarization of the society on religious lines for electoral gains. Basically, the Citizenship Amendment Act 2019 purports to give citizenship to the persecuted minorities in our neighboring countries who fled to India. But neither the CAA 2019 Act or the CAA rules whispered about the word fleeing from religious persecution as a condition to apply for Indian citizenship. As per the provision introduced in Section 21B, migrants belonging to Hindu, Sikh, Buddhist, Parsi, Jain and Christian religions from Pakistan, Bangladesh and Afghanistan are eligible for citizenship by naturalization if they can establish their residing in India for 5 years instead of the existing 11 years period condition. So all the undocumented migrants from these countries who entered into India before December 31st, 2014 are entitled to apply for citizenship under CAA provided they are non-Muslims. It is also noteworthy point that the Sri Lankan Tamil refugees who have taken asylum in India and Rohingya refugees who fled India from Myanmar are excluded. Notwithstanding the statements of the government and the ruling party leaders that this will not affect the citizenship of any Indian, the exclusion of Muslims creates any amount of doubt about the intentions of the government. Of course, the essence of CAA 2019 may not affect the interest of the minority citizens of this country, and it is only an enabling mechanism for minorities of the above mentioned three countries, namely the Pakistan, Bangladesh and Afghanistan, Hindu, Sikh, Buddhist, Jain, Parsi and Christian religious people to gain Indian citizenship. However, the main problem is that it's a discriminatory norm that specifies only certain religious communities are eligible, excluding Muslims, for citizenship, and they are presumed to have fled India on account of religious persecution in those countries. Others who do not fall in this category, either because of their religion or due to their entry in India after the cut-off date, will continue to be treated as illegal migrants. The problem is further compounded or complicated for that matter by the government proposal to introduce National Register of Citizens (NRC) and link it with CAA, and that the political propaganda added to fuel to fire by accentuating the fears of the Muslims that CAA may lead to the loss of their Indian citizenship without adequate documentary proof. Here I would like to cite an example of this fear which is widespread among our Muslim brothers and sisters. As soon as CAA rules are notified on 11/3/2014, on the next day, one of my Muslim clients, and who is a retired employee by name Sheikh Sajjad Hussain alias Sheikh Sajjata Hussain, he is aged 63 years, a senior citizen, approached me and requested me to prepare a sworn affidavit in respect of variation of his names in his school records, service register, passport and Aadhaar card, expressing apprehension that if CAA rules are implemented and he may need to put all the adequate sufficient documentary proof with regard to the difference in his name, and he was apprehending that though he is an Indian born citizen, he may lose citizenship and he may be shifted to the detention center, or he may be denied all his fundamental rights guaranteed under the Constitution. Such is the impression and fear created in the minds of the Indian Muslims about this move by the government. Unfortunately, no effort was made by the central government to allay such genuine apprehensions of our Indian Muslim brothers and sisters in any manner. On the other hand, there is a subtle message that all the policies of this government will have a majoritarian religious angle in all its policies and actions. Recently, I came across an article written by Manu Sebastian, Managing Director of the Layula, in which he explained very beautifully the discriminatory nature of CAA, giving an example of a recent case decided by our own Honorable Supreme Court of India in Anna Parveen versus Union of India and others. Anna Parveen and others versus Union of India others in 2022. And here is a case where the sons of a Muslim by name Muhammad Kamar filed habeas corpus writ petition before the Honorable Supreme Court, and this Kamar was aged 62 years and he has been under detention in a foreign detention camp since 2016 on the allegation that he is the Pakistani national. And his sons claimed in the writ petition that he is an Indian-born citizen, having been born in India in 1959, and at the age of 7 or 8 years, he has gone to Pakistan along with his mother on a visa to meet their relatives, and there his mother died. And being a child, he remained under the care and custody of his relatives there and returned to India around 1989 or 20 and married an Indian Muslim woman. And the 5 children were born, including the writ petitioners, and they were living in Meerut, Uttar Pradesh, and they are all Indian citizens. However, but in the year 2012, the police arrested him, alleging that he is an illegal migrant, and he was charged under Section 14 of Foreigners Act 1946, and he was sentenced to 3 years imprisonment. And after completion of the imprisonment in February 2015, he was not allowed to be released to come out of jail, since he was an illegal migrant, and he was shifted to Foreigners Detention Center. And the Honorable Supreme Court, of hearing this pathetic story of the Muslim Muhammad Qatar, and Muhammad Qatar advised the center and instructed the center to take humanitarian view of the matter and ordered his release. And he was released after ascertaining from the Home Ministry that he posed no risk, and also the court asked the center to consider granting him a long-term visa. Had this detainee, Muhammad Kamar, in this case, if at all he was a non-Muslim, definitely he would have got the benefit of CAA 2019 from the date of its enforcement, that is January 10th, 2020. Though the rules were notified on 11/3/2024. So therefore, in view of these illustrations which I have given, the brazen discrimination based on religion in CAA 2019 is undoubtedly a flagrant violation of law and Article of 14 of the Indian Constitution and the constitutional ethos as enshrined in the preamble of the Indian Constitution, and it is nothing but a potent weapon in the hands of the government with the legal and statutory base to implement its majoritarian, communal, hegemonic and divisive agenda. Yet still there is a ray of hope, as our Constitution of India gave us an independent higher judiciary to safeguard and protect the core objectives of the Indian Constitution, as I said, as enshrined in the preamble of the Constitution and in the form of fundamental rights. The Honorable Apex Court, being the custodian of the Indian Constitution and its mandate given to the higher judiciary, we hope that the Honorable Supreme Court of India will take up the pending cases relating to the validity and challenging the validity of CAA 2019 and its enforcement at the earliest point of time and live up to its sacred constitutional duty, as was done in case of electoral bonds scam case. I hope that the Supreme Court will take into consideration the negative aspects of the CAA 2019 and its rules, where this is violative of not only the fundamental rights and also Article 14 of the Indian Constitution, and also violates the federal spirit of the Constitution by denying any kind of role to the state governments, and will quash this, declare this CAA 2019 as unconstitutional, as it has done in case of electoral bonds. Thank you very much.